No society can surely be flourishing and happy, of which the far greater part of the members are poor and miserable. It is but equity. Besides, that they who food, clothe, and lodge the whole body of the people should have such a share of the produce of their own labor as to be themselves tolerably well fed, clothed, and lodged. Adam Smith. Hi, I'm Attorney J. Dreswen Carlo L. Palacio. Welcome to The Law Made Easy, the practical guide to modern living. Join us as we demystify the law and break it down into easy-to-understand concepts, empowering you to navigate contemporary societal intricacies with confidence and apply them practically in your daily life. The topic that we are going to make easy today is the principle of labor and its guarantees. Labor, ordinarily understood as the physical toil, although it does not necessarily exclude the application of skill. Thus, there is skilled and unskilled labor, while work covers all forms of physical or mental exertion, or both combined, for the attainment of some object other than recreation or amusement per se. While hard labor is an employee, wherein a person receiving a salary or compensation for another who controls or supervises the means and manner or method of doing work. Labor, in the point of view of our laws, are the terms and conditions of employment that employers must comply with, and to which employees are entitled as a matter of legal right. Nevertheless, it is significant to note that the Constitution enumerates rights of workers and not merely employees, which are the following: the right to organize themselves, the right to conduct collective bargaining or negotiation with management, the right to engage in peaceful concerted activities, including the right to strike in accordance with law, the right to work under humane conditions, the right to receive fair and living wage, and the right to participate in policy and decision-making processes affecting the rights and benefits as may be provided by law. In determining the existence of employer-employee relationship, the elements are generally considered comprises the so-called fourfold test, which namely, selection and engagement of the employee, the payment of wages, the power to dismiss by the employer, and the employer's power to control the employee with respect to the means and methods by which the work is to be accomplished. Absent the power to control the employee with respect to the means and methods of accomplishing his work, there is no employer-employee relationship between parties. Lastly, employer-employee relationship exists more clearly upon the circumstances where the whole economic activity is dependently based on the relationship between the labor and the capital employer, where one or the labor cannot sustain basic living in the absence of other performing basic economic activity for the capital employee. Employees, therefore, under our laws, shall enjoy at least a minimum wage pay to be determined by the Regional Wage Board. Sick leaves, maternity and paternity leaves with pay, overtime pay for more than 8 hours of work per hour, 5-day service incentive leave with pay for every year of service to the employer, night shift differential pay of additional 10% per hour for every work rendered from 10 in the evening to 6 in the morning on a workday, holiday pay, retirement, and separation pay, among others, SS, PhilHealth, and Pag-ibig contributions. Keeping with the basic policy of the state to afford full protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. All Filipino workers, therefore, whether employed locally or overseas, shall enjoy the protective mantle of Philippine labor and social legislation. Thus, any contract stipulations to the contrary shall be null and void. Why does the state afford protection to labor? Is protection to labor unfair to the employers? Can employers object to the constitutional protection to labor for being unfair? The answer is no. The Constitution addresses the historical disadvantage of workers in relation to employers by affording them special protection. Thus, the constitutional protection is not unfair to employers as it simply puts worker in equal footing with that of employer. The law, in protecting the rights of the employees, authorizes neither oppression nor self-destruction of the employer. It should be made clear that when the law tilts the scale of justice in favor of labor, it is but a recognition of the inherent economic inequality between labor and management. Never should the scale be so tilted if the result is an injustice to the employer. It should be borne in mind that social justice ceases to be an effective instrument for the equalization of the social and economic forces by the state when it is used to shield wrongdoing. Hence, social justice is neither communism, nor despotism, nor atomism, nor anarchy, but the humanization of laws and the equalization of social and economic forces by the state, so that justice in its rational and objectively secular conception may at least be approximated. Social justice means the promotion of the welfare of all the people, the adoption by the government of measures calculated to ensure economic stability of all the component elements of society, through the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community, constitutionally, through the adoption of measures legally justifiable, or extra-constitutionally, through the exercise of powers underlying the existence of all governments on the time-honored principle of salus populi, est suprema lex. I hope we made the principle of labor and its guarantees easy for you today, and broke it down to easy to understand concepts that will empower you to navigate contemporary society with confidence and apply this gift practically in your daily life. I'm Attorney J. Carlo L. Palacio. This is Law Made Easy, your practical guide to modern living.